what I'm going to do is I'm going to turn the computer. There's Mr. Adler, there's a respondent, and I will be off screen. Is that going to be okay with you, Mrs. Farmer?
Yes, Your Honor. Thank you.
All right, so Ms. Farmer, are you ready to proceed?
Space ready, Your Honor.
Mr. Adler, are you ready to proceed?
Ready, Your Honor.
Okay. Kelly, are you ready?
Your Honor, is the parent in the courtroom as well, or is she in a separate room?
The parent is right behind Mr. Adler, if you can see her on the camera.
I see her now. Thank you.
All right, so the court will call cause number 323-114-832-20. This is styled in the matter of Peyton Demerson. We are here for a Texas Family Code Chapter 54.02 hearing. That is for the state of Texas has requested the court waive its jurisdiction over this child and transfer this case to an appropriate adult criminal court. Before we begin, Ms. Farmer, do you have any objections for the record or any pre-trial matters?
Your Honor, we have some documents that we would like to offer.
Right, well, I'll get to that. I'm just looking for objections or pre-trial matters.
None, Your Honor, not at this time.
All right. All right, so the court will take judicial notice that on November 17th of 2020, the state of Texas filed a petition requesting the juvenile court to consider discretionary transfer to criminal court, which is commonly known as certifying a child as an adult, alleging 2 paragraphs of felony conduct, the court will find that in the underlying case, cause number 323-113284-20, the state of Texas filed on March 4th of 2020 a petition regarding child engaged in delinquent conduct, paragraph 1, which is aggravated robbery alleged to have been committed on January 20th or January 25th of 2020. Subsequently, the state of Texas on December 7th of 2020 filed a first amended petition regarding child engaged in delinquent conduct, alleging 2 paragraphs of delinquent conduct, the first one being aggravated robbery with a deadly weapon, namely a firearm, alleged to have been committed on June 27th of 2020, and in paragraph 2, the offense of aggravated robbery, which was alleged to have been committed on January 25th of 2020. The child was served with the grand jury approval of determinate sentence punishment that was filed with this court on December 9th, 2020. Served summons upon the child with a return date of December 30th of 2020. And a return of service on the mother, Pamela Singletary, with a return date of December 25th of 2020. The court did previously order a complete diagnostic study, social evaluation, and full investigation of the child, circumstances, and the circumstances of the alleged offense. So, Mr. Demerson, this is a hearing for me to give up my jurisdiction and transfer your case to an adult court. There are 4 things I must consider. And I need to consider whether the offense was against persons or property. I must consider the sophistication and maturity of you as a child. I must consider the record and previous history of you as a child in the juvenile system. And I must consider the protection of the public and likelihood of rehabilitation of you within the juvenile system. You must be at least 15 years old at the time of the offense, unless it's a first-degree felony, which aggravated robbery is. Then you have to be 14 years old. It has to be a felony level offense. And after the hearing and investigation, I have to find probable cause, and because of the seriousness of the offense or the background of the child, the welfare of the community requires criminal proceedings. Now, if I do certify you, then what has to happen is immediately I must set a bond for you, and I will transfer you to an appropriate adult criminal court to finish out your criminal proceedings. I do believe that you have adult criminal cases that you're facing right now downtown. Okay. And if there's an agreement, and I know there's an agreement in this case, I'm asking you to give up your right to appeal. Do you understand? Okay. All right. The court will also take notice that there is a stipulation of evidence filed today with this court at 1:15 in the afternoon that is signed by the both parties but not approved by this court. The court is allowing the child to withdraw his plea of true from the stipulation. However, there is another stipulation of evidence, first amended stipulation of evidence filed at 1:29. And filed with this court and appropriately marked. Now, Mr. Demerson, do you understand what a stipulation of evidence is? I don't expect you to. It's a legal word. Stipulation is a fancy word for an agreement. Okay? If two people stipulate to something, that means they are going on the record in court legally saying they agreed to something and that they could never go back and undo it. So 20 years from now, if there's a stipulation here, you cannot go back and argue about what's inside the stipulation. Do you understand how important it is? And you understand how important it is to make sure that you're very aware and intentional about what you stipulate to. Okay. So what I have here is a first amended stipulation of evidence that your attorney gave me. Did you look over this with your attorney? You had a chance to go over it with him. You had a chance to answer or ask him questions. Okay. And so on the last page, kind of the top left signature line, there's a signature line. Do you recognize that signature? Is that your signature? Did anybody force you to sign this? Anybody bribe you to sign this? Anybody offer you like cash or a reward to sign? Did you sign this voluntarily? Okay. What does the word voluntary mean to you?
Me agreeing by myself.
Okay, and you agreed to sign this by yourself. Okay. And you understand by stipulating this, you're also agreeing that I would give up my jurisdiction and transfer your case to an adult criminal court. And that's what you want. Nobody forced you to ask for that. Nobody bribed you or offered you money. Okay. And you're asking me to transfer my jurisdiction voluntarily, is that correct? Ms. Moreno, did you have anything that you want to add? Or Ms. Farmer?
No, Your Honor.
Okay. Mr. Adler, anything to add?
No, Your Honor.
So the court, having considered the complete diagnostic study, the social evaluation, and the full investigation of the child, circumstances of the alleged offense, will find that the child was at least 15 years old at the time of offense, or 14 years old since this was a first-degree felony. The child has not been adjudicated yet on the matter, that this is a felony level offense. The court will find that there is probable cause that the child committed the offenses of aggravated robbery, and because of the seriousness of the offense or the background of the child, the welfare of the community requires criminal proceedings. The court has considered whether the offense was against person or property, the sophistication and maturity of the child, the record and previous history of the child, the protection of the public and likelihood of rehabilitation of the child within the juvenile system. Specifically, the court is considering the seriousness of the offense and the history of the child in the reasons for its transfer. So at this point, Mr. Demerson, I've given up my jurisdiction. I'm transferred this to an appropriate adult court. You are at least 17 years old, so I'm going to continue to have you housed in the custody of the Tarrant County Sheriff in the Tarrant County Jail. I must set a bond amount now. I'm going to set the bond amount at $20,000. My understanding is the magistrates looked at your offenses. You have an engaging or organized crime with an underlying aggravated robbery case downtown, and that is set at $25,000. Because this is a juvenile case, I'm going to set it just a little bit lower, okay? Or this came out of a juvenile case. So if your family is able to make bond, then they can. If they can't, and the bond has to be lowered, that would have to go to the adult court. So it will no longer go to me, okay? After this hearing, I will not be able to sign anything on your case. Okay? Now, because I followed your agreement and you asked me to, you do not have a right to appeal, but this will be final, you understand? And if you want to go back on that, this is your chance, but you wish to have this, correct? Okay. Mr. Adler, if you can give this one copy to the child and one to the mother. All right, thank you. All right, Mr. Jefferson, do you have any questions for me? Okay, I wish you the best of luck. I hope things work out for you. Is Keith your attorney? McCabe? Okay, he's a good man. I remember when I was an attorney practicing with him, so I hope things work out for you. Mom, do you have any questions for me? Okay. Mom, do you have any questions for me? Okay, Ms. Farmer, have I missed anything?
Your Honor, has the court, were the documents filed with the court, the pre-diagnostic, the victim court report, as well as the 3 discovery manifests?
Yes, there are 3 discovery manifests. I do have the pre-diagnostic study, the victim's court report, which I have filed under seal with the court in the jacket. I also have, let's see, let me put this in the envelope. The 33914 manifests. I have a stipulation of evidence, a first amended stipulation of evidence, and a order of waiver of jurisdiction, an order of transfer to a criminal district court, an agreement to waive jurisdiction, an order of detention in the Tarrant County Jail, and a certification of juvenile's right to appeal. You need me to hold it up to the screen so you can see them, Ms. Farmer?
No, Your Honor, that's not necessary.
Anything else, Ms. Farmer, that I missed?
No, Your Honor, actually one other thing, Your Honor, as far as the bond, I know that you just set it at $20,000, but the state would ask that, given the facts of the case, you would consider matching the bond to what the amount is at the district court.
Right. I'm going to leave that up to the discretion of the district court. They can always lower and raise the bond, but it's a kind of my rationale behind this is the scrutiny, the supervision given by the federal courts on criminal bond matters. I'm concerned about when you have multiple offenses, just keep on matching it because it starts to become punitive based on the things I've been reading. But it makes it a total of, it's the same offense, it's just more of them, but also was committed as a juvenile when the child had a lesser state of mens rea. So that's just why I said at 20, but the adult court, of course, can raise it anytime they see fit. Okay. Anything else, Ms. Farmer?
No, Your Honor, thank you.
Mr. Adler, have I missed anything?
No, Your Honor.
All right, then I'm going to turn this monitor around. All right, that'll conclude everything. That'll be the order of the court. Thank you, everyone.
Thank you, Judge.
Okay.